Thanks, Kevin. Good afternoon or good morning to some of you, I suppose. Good afternoon to the rest of you. My pleasure to be here. I'm a longtime member of the Text and Academic Authors Association. For those of you that don't know me, a longtime council member, and I happen to be an attorney in Cincinnati, Ohio, that has a practice focused on publishing, media, and copyright. And I'm a relatively frequent speaker at these conferences, and this one is no exception. So the topic is the law and policy of Chegging. That's because there was one case that I wanted to make a presentation about at the time I pitched my presentation, and that was Pearson versus Chegg. Since then, there have been two other cases added. And we'll talk about those in a second. But before we do that, make a note first, if you will, of my email address, because it may happen that you have a question that I'm not able to get to during the session, or you may think of something else after the session, and the best way to reach me is by email. I'll try to respond promptly with the answer to your question, or if it happens to be the case that I don't know, I'll tell you that as well. Another reason to have my email address is because the first case that I'm going to talk about, Pearson versus Chegg, involves, has attached to the complaint in that case a list of 150 specific Pearson titles that are the basis for their claim identified. And I know that that for some of you here in this session right now, that your textbooks are among those. And so you may like to have that list to see whether or not your book has been identified if you happen to be a Pearson author, and you may be curious about others. So, as I said, three noteworthy cases. The first is Pearson Education versus Chegg, filed in September of last year. The second is Macmillan Learning and four other publishers filed against Shopify in December of last year. And then most recently, Yone et al. Versus Paramount Pictures just filed early this month. And you may wonder what that's about. It happens to be about the Top Gun sequel that was recently released late last month. And Yone is the author of an article that was the basis for the original movie and then the basis for the sequel. And you might wonder what that has to do with textbook publishing. And when we get there, I'll make the connection for you. So with respect to the first case, Pearson versus Chegg, what is Chegg and where did it come from? Well, the first thing of interest is that Chegg is a mashup of the words chicken and egg. And the reason that the founder chose the name Chegg was because he was a graduate student in engineering, and he was frustrated with the notion that he couldn't get a job until he had experience, and he couldn't get experience until he had a job. So he decided to found this company that started as an online campus flea market, and he called it Chegg, which is a mashup, as I say. He started this in I have something in the way of my started this in 2000. By about 2000 as an online campus flea market. So just selling things that were of interest to students on campus. By about 2005, the company had sharpened its focus to textbook sales and rentals. The founder had realized that there was an opportunity to if they could provide textbooks at less than the list price, to compete with publishers in this market. And by 2007, it had shortened its name to Chegg. At the same time, on a parallel track, there was another company being formed in 2002, an online startup that was focused on providing answers to math, science, and engineering problems. But there was another engineering student who realized that there was a market for answers to or solutions to the problems that were appearing in these books. But in order to make this business viable, he needed to quickly amass a large collection of answers, and he needed to do that in an economic way. And so his solution to that problem was to send the problems to India and have Indian students write the answers. So he was able in that way to amass a large volume of answers in a relatively short period of time at a pretty low cost. In 2010, these two companies came together when Chegg acquired Cramster, which was then rebranded as Chegg Study, which is what it is now, offering solutions to text questions, including questions from Pearson texts. So 2010, the two companies come together. Chegg is providing answers to Pearson texts, and Pearson knows this is going on. And around April 2016, Pearson agreed to actually license to Chegg the right to include Pearson text questions verbatim in the Chegg Study service. In 2017, the next year, Chegg and Pearson expanded their relationship by beginning a textbook rental partnership. By 2020, that was the beginning of the pandemic, when we went from face-to-face instruction to in some cases, asynchronous online instruction. Chegg suddenly had an expansion as students who are now not face-to-face in classrooms, but sitting wherever they're sitting in front of their laptop, nobody looking over their shoulders, realize that Chegg has answers. And so Chegg's subscribers were at that point 6.6 million, having increased by 67% over pre-pandemic times. And having increased its revenue by 57% to $644 million, the majority of which came from Chegg Study. Remember that fact, $644 million in 2020, the majority of that coming from this Chegg Study service. At its peak in early 2021, Chegg had a market capitalization of almost of $14 billion, but today, after the Pearson lawsuit and for some other reasons, its market capitalization has dropped to about $2.4 billion. So roughly a seventh of what it had been just a year ago. In May of 2021, Pearson terminated the Chegg Study license. Seeing how successful Chegg was, I think Pearson might have decided that it could possibly get in this business itself and reap some of those benefits. And by September, a few months later, it had filed this suit. What's Chegg accused of doing? Well, Pearson claims its questions is copyrighted works, and that the answers to those questions are what we call derivative works in the copyright sense. And a derivative work is a defined term in US copyright law. You can see the definition on the screen. Essentially a work based on one or more pre-existing works. So you take an existing work, you get a head start from that existing work in creating something that is similar but not identical. Here's an example of how an answer might be derivative of the question. This was an example from one of the textbooks that's at issue in this litigation. You can see that the question on the left, the answer on the right, and the words that are in orange are the same. So a substantial part of the answer is comprised of language that was taken directly from the question. This happens to be one example of 702 answers from a single textbook. What is Chegg accused of doing? There were, back up. There were three textbooks that were singled out for this sort of attention in the complaint. One was a biology textbook where there were 759 answers to questions taken from the book. One was this one, an anatomy textbook where there were 702 answers. And then there was a basic math book where there were 7,827 questions that were answered. What's Chegg accused of doing? Well, among the rights that belong exclusively to the copyright holder are the right to prepare derivative works, the right to reproduce the works, and the right to distribute the works. Three distinct rights. And Chegg is accused of unauthorized exercise of each of these rights with respect, as I say, to at least 150 specifically identified Pearson texts. Pearson also gives a nod in its complaint to Chegg's unauthorized publication of answers as undermining the value of the questions for teaching and evaluation purposes and facilitating student cheating. But I think it has a problem making too much of this argument, which makes it seem like the Chegg Study Service is unethical and wrong. But then there was that period of time for 5 years when Pearson was happy to sell these questions to Chegg for the purpose, the same purpose that they're being used today. So when it comes to a copyright infringement claim, there are three elements. And the first is to establish ownership of a valid copyright. The second is to establish that the accused had access to the source work, because independent development is not copyright infringement. You must have had access to the original, the opportunity to copy or extract content from it that's protected in order to be guilty of infringement. And then there has to be an unauthorized exercise of one of the exclusive rights with respect to the copyrightable elements of the source code. As to the first element, registration creates a presumption of validity, but it's a rebuttable presumption. So as a matter of proof, you introduce your registrations, you have to have a registration in order to get access to federal court for a claim. And so, insofar as Pearson might not have registrations for all editions of each source work, and it does have gaps in its registration record, those works that it doesn't have registration for are not eligible for as claims in this case. I say registrations for all editions of each source work, and here's why I say that. When a work is first created and published, everything that's in the work is eligible for copyright protection. When that first edition is revised, then in the second edition, the only thing that is eligible for protection under the copyright that applies to the second edition is what's new in the second edition. And as you know, you don't replace all of the questions in every edition of the book, edition by edition. You replace some of them. And so if we're going to cover all of the questions in the current edition of a book, we need to have registrations for all of the editions leading up to the current edition to be sure that we have a registration for every question that might be infringed by Chegg. And I know that Pearson has gaps in its registration record. If challenged, Pearson has to prove that it acquired copyrights from each author by written agreement. I think that's not going to be a problem for the textbooks by and large, but it might be problematic for questions that were provided by contract writers, because they're a little less careful about that. As to proof of access, well, for at least 5 years, Chegg had licensed access, and the 150 works that are specifically identified in that exhibit to the complaint are for the most part current editions of their successful textbooks, and the vast majority of them were first published in that 2016 to 2021 window. There are some a small handful that go back as far as 2012, but it's a relatively small handful. And outside of the 5-year period, when Chegg had licensed access, the source works are published and in wide use, even those going back to 2012. And so we might reasonably infer that Chegg had access to these works, because the ones that they are providing answers to are ones that have been widely adopted, such that there's a market for those answers. So with respect to use of copyrightable elements, this may be problematic. because copyright covers works of original authorship. The bar of original authorship is pretty low. We don't make aesthetic decisions about whether it's literary work or artistic work that has merit. If there's something original about it and a modicum of originality, then it's going to be protected. But answers to some questions can be problematic. I'm thinking here of math or engineering or statistics questions. The answer 4, for example, to the question, what is 2 plus 2, is not going to be copyrightable. The number 4 is not copyrightable. Pearson attempts to head off this challenge in its complaint, and it says, and I'm quoting here, the publisher or Pearson and its authors devote significant creative effort to develop effective, imaginative, and engaging questions, strategically designed and carefully calibrated to reinforce key concepts, test student comprehension, enhance student problem solving, and improve students' understanding. These questions are hallmarks of Pearson titles. Well, that sounds great. Remember it when Pearson offers a lowball fee to you for writing end of chapter questions, and maybe you want to quote some of this back to them. Pearson also claims a compilation copyright in the selection and arrangement of the questions. Remember back to that one specific example where there were more than 7,000 questions that were answered, in the same order in the chapter by chapter and so on as the arrangement of the questions. And then Pearson claims both literal and non-literal copying. We saw an example of literal copying in that sample question and answer that I showed you. Non-literal copying refers to copying of character descriptions and plot, and you think that maybe there isn't a lot of that, but there really is a surprising amount of creative elements that go into a word problem, for example. So let's talk about the ethical issue, even though Pearson's going to have a little bit of difficulty making much of this. Chegg promotes its service as a study aid, and in January of 2021, it announced, in the face of increasing criticism from the public about making answers available to textbook questions, announced the launch of a service called Honor Shield that permits instructors to submit exam or test questions in advance to permit them from being answered on the Chegg platform during a time-limited exam period. They don't say, how much time these would be unavailable to certain students. I know from my years of adjunct and service as an adjunct instructor that I was lucky to get my exams completed in time to administer them, let alone sufficiently in advance that I could have submitted exam or test questions to Chegg to try to get them blocked from my students for a short period of time. Use of Chegg to avoid doing one's own work or as an outside resource for answering exam or quiz questions would be a violation. I think it's pretty clear of just about every school's student honor code. Use of the service, as I said, grew dramatically on the switch over from in-person teaching to online teaching when students were not being monitored in face-to-face instruction. And around this time, Forbes published an article about Chegg study where they interviewed 52 students from 19 colleges, and 48 of those students admitted that they used Chegg study to cheat. In fact, Forbes article concluded that Chegg was a super spreader of cheating. At the end of the spring 2020 term, North Carolina State lecturer caught 200 students using Chegg to cheat on his introduction to statistics course. Having struggled with statistics when I took it back in the days when I was in college, I'm glad that I was not confronted with the Chegg temptation to the shortcut, the process of taking that course. What is Chegg's exposure here? First of all, really So there could be an order from the court that Chegg has to stop if it's determined that they're infringing, in fact. And remember that of over $500 million in revenue, the vast majority of it comes from Chegg studies. So injunctive relief would be pretty much the end of the Chegg business. That business that was just a year ago had a market capitalization of $14 billion. Provable actual damages. Sometimes actual damages are difficult to prove. In this case, it wouldn't be difficult because there was a 5-year period when Chegg was willing to pay for access, a license fee for access to these questions and the license to publish the answers. And so we have a record of an arm's length transaction where they indicated what they were worth. Alternatively, and probably preferably, there are statutory damages available in this case of up to $30,000 per work infringed. Remember the exhibit that has 150 different titles, or up to $150,000 per work infringed if the infringement is willful. And I think here it's pretty likely that we're going to end up with that sort of finding. Now we have, as I say, 150 works listed in the exhibit to the complaint, but remember that Pearson will have to establish that it has registrations for all editions of those works. Those tend to be the more successful works. So in their current editions, they've been around for a pretty long time. If the average is that the current edition is the 10th edition for each of these works, and that wouldn't be unreasonable, then the total number of registered works that we're talking about here might exceed 1,000, which means that the maximum statutory damages exposure for Chegg would be $150 million. Nothing to sneeze at. In addition, if Pearson is successful, it may get an award of its attorney's fees. A lot of lawyers involved in this case, 2 law firms and 3 lawyers for Pearson, and 3 law firms and 7 lawyers for Chegg. So Chegg is going to have to pay its lawyers, and it may also end up having to pay Pearson's lawyers as well. And know that Chegg has been separately sued in a class action by its investors, who are complaining that this jump to $14 billion in value in 2021 was illusory and perhaps fraudulent and based on illegal conduct in a pandemic, rather than as Chegg would have its investors believed the business acumen and success of the business. Chegg has answered, and it says, that it provides on-demand, low-cost educational support to help students realize the value of the education for which they pay. This is kind of a backhanded slap, I think, at textbook prices and greedy publishers. It provided original answers for 6 years and took a license for 5 more. So there's 6 years when it did this and it was unchallenged, and then it took a license. And in that license document, there are some recitals, and I suspect that most recitals is an acknowledgement that Chegg has been doing this, but now it wants to take a license. And Chegg is going to point to that and say, well, not only did we do this for 6 years unchallenged, but Pearson knows about it and has acknowledged that we do it. We did it, tacitly admitting that we had the right to do it. Another defense raised in Chegg's answer is that Pearson's copyright in the questions does not give it a monopoly over the answers. And here specifically, I think we're talking about answers like 4 to the question, what's 2 + 2? Chegg denies that it offers answer sets. So that's the selection and arrangement, the compilation claim, but admits that students can access 6 million original solutions to questions in 9,000 texts outsourced to its experts. Those experts meaning the contractors in India. And then Chegg claims a number of other sort of catch-all affirmative defense like fair use and copyright misuse. The fair use defense would be interesting, and I think for questions that are in the nature of math and statistics and engineering problems. I think there may be a fair use argument. The problem with that is a fair use is a defense. It has to be evaluated on a case-by-case basis. So that means that the answers to thousands and thousands of questions have to be evaluated one at a time. There was a case a few years ago where the University of Georgia was sued for its online reserve policy, where it was making copies of substantial portions of textbooks and making them available online to students without getting permission. And this case involved 99 specifically identified works as opposed to 150 or 1,000. And the opinion, which had to evaluate how the University of Georgia had addressed each of these each of these textbooks case by case, the opinion in that case was 350 pages long. So 99 works resulting in a 350-page opinion. Imagine the work that would go into the analysis of fair use defense with respect to thousands upon thousands of questions. Copyright misuse is a theory that says that Pearson is using its copyrights in an attempt to overreach and get more protection than it's entitled to. I don't think that has much likelihood of success. Express license, well, there was an express license for a period of time, so those claims with respect to what was done under a license are not going to be viable. Latches and acquiescence are defenses based on that notion that you didn't complain soon enough. Unprotected expression, that certainly if the question is 2 + 2 = 4, that's going to be successful. DMCA safe harbor, we'll talk more about this when we get to the Shopify case, but that's essentially immunity from suit for what we call an internet service provider. That is somebody who facilitates communications but doesn't create the communications. So think of a social media provider or a blog host or some other service that just provides a platform for its members to communicate with each other or to comment, for example. But we don't have that here because in order to take advantage of the DMCA safe harbor, the accused site has to be a passive provider of a service that allows the communication to take place, not the author of the communication. And here, the communications that are complained of were done by contractors to Chegg. Statute limitations. You have a 3-year statute limitations for copyright claims, and so the claims in this case are only going to go back to things that happened over the past 3 years. Where does the case stand now? Right now, we're 9 months into this case, and the parties are embroiled in highly contentious discovery disputes. There's a process in litigation where the parties are entitled to request and compelled to provide information and answers to questions from the other side so that they can be fully informed. But this can be contentious, and in this case, it is very contentious. The issues in the parties' respective positions on these discovery disputes were set forth in the letter to the court in early May. There was a hearing held earlier this month, and we don't have a decision yet on the issues that were presented there. So we're still pretty early in the case. Fact discovery is set to close on November 1, and so we need to get this. I see that I have a question with a raised hand, and I don't know if the moderator can unmute. Okay, your question.
Hi, you have me so excited. I'm speaking to the screen. I'm thinking, oh my gosh. Okay, here's the question. What, in your estimation, should Chegg have done instead of what it did in the beginning?
I'm sorry, you're breaking up a little bit for me.
Okay, can you hear now?
Yes.
Okay, what in your estimation should Chegg have done instead of what it did? Like, how could it have moved better to protect itself and maintained its financial success and legal peace?
Oh, that's a good question. That if they had adopted a policy or a process that really did prevent students from using their service to cheat, that really did what they claimed they were intending to do, which was help them understand why the answers that they had created on their own were not correct, and what might have been correct in the, to help them reinforce the lessons that they were learning rather than a shortcut to the answers. That might have gone a long way toward appeasing Pearson. But at the end of the day, the only absolutely safe way to do this is if Pearson were willing to grant a license, which it was for a period of time, and then until it wasn't.
Do you think they made a mistake by, I'm not saying I'm not for Chegg or against Chegg. I'm just learning about this case through you, but do you think like maybe they did something wrong here? I'm an English professor.
Well,
Obviously,
yeah,
if I took word
I
for
think,
word, this
yeah,
is wrong, but
I think they absolutely did something wrong. I think this case is very likely to go against Chegg.
mhm.
The trial is expected in mid to late next year, and I think it probably will have to go to trial because I don't see either party able to settle this case. I don't think that Chegg is in a position to walk away from from this business. It's not in a position to say, okay, we'll stop and we'll pay you some damages, because this is the largest part of their business. If they stop doing this, their business basically dries up and blows away. And I don't see Pearson as agreeing to allow this practice to continue, except under some very significant restrictions. And so I think this case will probably go to trial. Okay, let's turn our attention to Macmillan and four other publishers versus Shopify. Here we've got 5 publishers suing Shopify in the Eastern District of Virginia. So we have Macmillan and its subsidiary Bedford Freeman and Worth. We have Cengage, we have Elsevier, we have McGraw-Hill, and Pearson is involved in this case as well. And what's Shopify? Well, Shopify is a Canadian corporation with its headquarters in Ottawa, but it made perhaps the mistake of owning servers in Virginia. It has a market capitalization in 2022 of $110 billion as compared to $14 billion for Chegg at its zenith a year ago. It is among the world's largest provider of e-commerce services. So it's like an online shopping center where folks can open a store, pay a subscription fee for that, for the privilege of using that store on that site, and then pay per transaction fees on top of the subscription fee. So more volume means more subscribers and more transactions and more revenue, an inherent disincentive to police against pirates. And what Shopify does is provide its subscribers, and the complaint alleges including known infringers, with the complete online shopping and fulfillment services. The complaint says it hosts a world of digital textbook pirates. It routinely ignores illegal activity, and even though it has policies against piracy, it doesn't enforce them. The claims are for something called contributory copyright infringement. Here, they've identified 3,406 registered works that presents the potential for over 500 million in potential statutory damages. There's another theory called vicarious copyright infringement. We'll talk about contributory copyright infringement and vicarious copyright infringement in a minute, and I'll explain the difference between them. But it's 2 paths to the same result. And then they have alleged contributory trademark infringement concerning 20 registered trademarks with the potential for $40 million in damages. So well over $500 million at risk here. Contributory copyright infringement is a theory that holds somebody responsible who isn't a direct infringer, but who made it possible for somebody else to infringe. The difference and vicarious copyright infringement is a similar but different theory to get to the same place, to hold somebody who didn't directly infringe responsible for infringements that they somehow or other facilitated. The difference is that Shopify, for contributory infringement, Shopify must have known or should have known of the infringing activity and that it facilitated or contributed to the infringement. Here in the complaint, the publishers say, we sent hundreds, if not thousands, of takedown notices, and Shopify was well aware of this infringing activity, and that it provided the online services that made this piracy possible. And for vicarious copyright infringement, again, we've got direct infringement by pirates, and Shopify had the right to control infringing activity because the pirates had to sign on and agree to terms of use that gave Shopify that right. And Shopify had to receive a financial benefit from the infringing activity. And as I pointed out earlier, more volume, more subscribers means more money for Shopify. The defenses, this was interesting. Among the defenses raised by Shopify was a defense that it's the universities and not the professors who are the publishers who are the rightful copyright owners, because they said these professors who authored these textbooks work for universities. They're faculty at universities for the most part, and the faculty are therefore employed by the university, and the university expects them to write and publish in their field. So it's within their duties as faculty members to do that. And that's a classic definition of work made for hire. The problem is that most universities have published intellectual property policies that disclaim any interest in ownership of the academic writings of their faculty members. I think what Shopify will argue is that a university policy can't trump black letter copyright law. I don't think they're going to be successful with this, but I've heard from at least one person, a faculty member or author, who has learned through Pearson, I believe, that no, through a different publisher, one of the publishers in the case, that Shopify had subpoenaed his university for his personal records and personnel records and things like that, all directed toward this defense that it's the universities that own these works as work made for hire. I think that my understanding is that subpoena has been quashed, and I suppose that if there are others out there, they've all been quashed as well. But that was an interesting theory that didn't get very far and probably won't be successful. Here, DMCA's safe harbor is a viable defense because Shopify isn't a direct infringer. They do provide the facility, but don't provide the content themselves. However, it's not going to be available to them in this case for reasons that we'll talk about. Estoppel, waiver, and latches, those are all defenses based on the allegation that the publishers waited too long to raise their claim. Copyright misuse we've talked about. They say there's no direct infringement, but that doesn't end the case. They're claiming no financial benefit, excuse me, and no knowledge to avoid the secondary liability. They're claiming certain works are not registered. There's probably something to this, but I don't know how many of the works it will affect. And they're arguing implied licenses to the trademark as to the trademarks, and that's not going to fly. And fair use, presumably, as to the trademarks, although they don't say. And this may actually be successful with respect to the trademark claims, depending on their argument. So you see, most of these defenses, in my view, don't have merit. The DMCA safe harbor, theoretically, but not practically, under the terms of this at issue in this case, statute of limitations will have some impact because it's a bright line against claims going back more than 3 years. Certain works not registered, this won't make them all go away, but it may make some of them go away, and there may be a fair use argument as to the trademark infringement claim. So as to the DMCA safe harbor, first of all, you have to be a service provider in order to take advantage of this shield against liability, not a direct infringer. So you have to provide the service, but not the content. You have to have an established takedown policy and procedure so that if somebody complains that content on your site is infringing, you must and they do that in the right way, you must promptly take it down. You have to have a designated agent registered with the Copyright Office and identified in notices on your site so that people know who to send their takedown notices to, and you have to promptly take the accused material down. But a large service like Google gets about 3 billion takedown notices a year. That's almost 6,000 notices per minute for every minute of every day of the year. That's a lot. And so the takedown process for something, a service like Google, needs to be pretty highly automated. And there are opportunities for that to not work perfectly all the time. So we have to take that into account, although with Google, that is in terms of scale. Google has a market capitalization of $1.4 trillion as opposed to $110 billion of Shopify. So we're talking about a scale that probably Shopify doesn't have to contend with. There must be no awareness that this is taking place. The courts talk about red flags awareness or willful blindness. A few years ago, Cox Communications suffered a $1 billion damages award based on willful blindness to infringement on its website of 10,000 musical works. And so, willful blindness can add up. The DMCA also has a requirement that in order to take advantage of the safe harbor, you have to deal with repeat infringers. It doesn't define what a repeat infringer is. It doesn't say, that's somebody who infringes X number of times over X number of months. It leaves that to the operators. But what it does say is that if you establish a policy that identifies what a repeat infringer means, then you must follow that policy. And pictures in this case are claiming that Shopify did not follow the policy.
Hey, Steve, you have someone, Elsa has her hand raised. Elsa, you want to go ahead with your question?
Thank you.
Yeah, Elsa.
Thank you. Yes, please. So what you're describing with Shopify sounds rather similar to what I've discovered with Course Hero, working with one of my clients. And I apologize, my name's showing as Elsa Obachowski, but I'm known by my maiden name, Elsa Peterson. And part of what I do is copyright and permissions work for publishers. So we've discovered the Course Hero, if I understand correctly, actually pays students to put up portions of courseware or textbooks after the semester is over, and it claims that, well, this is old content and so it doesn't matter, it's okay to put it up, when in fact, of course, we all know that a textbook doesn't go out of use after one semester. Right. So I'm curious whether you're familiar with Course Hero as well.
I am. In fact, when I was teaching as an adjunct, some of my material was posted on Course Hero, and I found out about that accidentally when I had a student one semester with absolutely perfect answers to every question that I asked, and I couldn't understand how that happened, and then I discovered how it had happened. I wasn't aware that Course Hero actually paid students for this content. I thought students were just posting it to help each other, but be that as it may, Course Hero is very much smaller than any of the companies here, very much smaller than Shopify, very much smaller than Chegg. And so it hasn't, it hasn't been a target, although certainly the outcome of the Chegg case will make that, make it more likely that Course Hero would be challenged. Can somebody give Cassandra Baker the ability? Yes.
She can just speak up. Yeah.
Hi. Elsa, I just want you to know I've had the same problem with Course Hero, that I found my test banks out on Course Hero. I've had to contact Course Hero. I've had the publisher to contact Course Hero, and they will take it down, but then maybe a few months later, you'll find it back again at the end of every semester. So it's something that I, as the author and the publisher, have to constantly police. And I found it by doing a basic Google search, Googling my book to see, what's being said about it. And that's how I ran across Course Hero. It is a problem. It is a problem. And I just didn't find my book, but, and the test banks, but the courses I teach, Introduction to Business, Quality Management, Leadership, I found all those tests out there also. So I don't know what to do about it.
Cassandra, if I could interrupt for a second, my time is getting short here, and I've got one more case to talk about. Thank you for your comments, though. I understand that Course Hero is a problem. So where do things stand with this case? Well, I think Shopify made a strategic mistake when they established a presence in the Eastern District of Virginia, because the Eastern District of Virginia is known as what lawyers call the rocket docket, and it boasts of file to trial in an average of 11 months. So this case will get resolved pretty quickly. There are some confusing entries in the scheduling orders in the docket in the case because it's moving so quickly. Nominally, it's headed for trial in August, but I don't see how that's possible. But the theoretical exposure here is more than half $1 billion plus attorney's fees and costs. So let's turn to the last case. This was the Top Gun case, the Top Gun sequel case. And you might wonder what this has to do with textbook publishing. Well, the plaintiffs in this case are the widow and son of the author of an article entitled Top Guns that was published in May 1983, a pretty long time ago, in an issue of California Magazine, a magazine that doesn't even exist. But it was an interesting story, and it caught the attention of filmmakers at Paramount, and within weeks they had negotiated with the article author for dramatic rights to make a movie based on that article. That original movie was released in 1986. The original movie was thus a derivative work of the original article. There is a right that belongs to all authors under U.S. copyright law to claw back rights that you sold after 35 years. And so on January 23, the widow and the son, the article author having passed away, his widow and his son together served a notice of termination on Paramount to take advantage of this. 2 years later, on January 24, 2020, dramatic rights reverted to the Yones. Paramount completed a sequel called Top Gun Maverick in May of 2021. This is more than a year after the rights had reverted to the Yones, and they didn't get a new license. And that is pretty plain and simple copyright infringement. The complaint includes a 19-page chart of similarities between the magazine article and the sequel. So clearly the sequel is based on that original magazine article. The sequel generated a global box office of $357 million in the first 10 days of its release. Now that number is up to $800 million as of 4 days ago. The budget to make the movie was $170 million. There's a lot of funny business that goes on in terms of calculating profits in the film industry. So it's likely that the profits are not going to be $600 million or something like that, but there'll be plenty of argument about it. Claims are for a declaration from the court that the owners are the copyright holders, that this was a copyright infringement, and probably a claim for actual damages in this case, which are going to be much higher than the statutory damages asked for in the other cases, and injunctive relief, of course, which would be catastrophic. No answer's been filed yet. This case is less than a month old, but Paramount has hinted that its contention is going to be, its defense is going to be that the sequel was sufficiently completed by January 24, 2020. That's almost a full year before it was actually released. And I'm not, the textbook publishers are going to be paying attention to this case because they're going to want to find out what's sufficiently completed means, because see here. Termination of a grant can be effected notwithstanding any agreement to the contrary, including an agreement to make a will or make any future grant, until after the notice is served, and then you can renegotiate with the original publisher if you're so inclined. If there isn't a successful renegotiation of a re-grant, then the copyrights revert actually to the authors, who are in this case the heirs of the article author, on the effective date of termination. Any derivative works that were created prior to termination, however, may continue to be exploited. So if it's determined that this sequel was substantially completed, sufficiently completed, prior to the effective date of termination, then that movie can still be released under the authority of the original grant. If, however, it's the release date that determines whether or not it is still prepared under the authority of the original grant, then it's going to be to continue to show that movie is going to be copyright infringement. Okay, I know that was a pretty rapid fire copyright litigation through a fire hose. I apologize for that, but I only had 60 minutes and we had a lot to talk about. Now, Cassandra or anyone, I'm happy to take questions. Robert.
Has Macmillan or Pearson in their brief or statements established how they're going to compensate the authors of these works?
I'm glad you. Yeah, I'm glad that you raised that question. If you have a contract that is an older contract that goes back to maybe the 80s or late 70s, then there's a fair chance that contract is going to have a language in it that deals with the prospect of litigation. It's going to say that the publisher has the right to file a suit, that you have the right to join them and share in the expense of that suit if you so elect. And if you do that, then any winnings are going to be shared 50-50 between you and the publisher, or it may provide that you don't have to join, in which case you get your royalty share of any proceeds after expenses are covered. And there are other folks with newer contracts where that language is probably not going to be in there. And it'll be interesting to see whether Pearson or Macmillan or any of those other folks, if they get a recovery, if they notify their authors of that and offer to share the proceeds. I think I know how that's going to go, but I'll be interested to see. Anyone else? You see my email address here again at the bottom of the screen on the left in blue. If you have questions or if you want a copy of that exhibit from the Chegg complaint, just email me and I will share it. It looks like there are 10 questions in the chat, but I can't see the chat with my screen display. Kevin?
I don't see any questions right now in the chat, unless I'm missing something. Yeah, a lot of people saying thank you.
Oh, okay. Well, those are the kind of questions I like, Kevin. So
Yeah, that's
let's
right.
encourage it.
Well, I'm going to look up the answers on Chegg to those questions. And now that I know, I learned so much from these presentations. And seriously, Steve, and our kickoff meeting this morning, I've already earned back the price I paid for registering for this workshop. And we appreciate all the work that you put into preparing this for us and bringing us up to date on some important issues in authoring. And with that, we're out of time. Thank you all for attending.
Thank you, Kevin. You're very kind.